Good afternoon. Thank you for joining us today. We appreciate the opportunity to entertain this conversation. I'm Bob Kincade, President, Portfolio Manager of Stonebridge Capital Advisors. Next to me is Ron Hume, Executive Vice President and Portfolio Manager. Today, for those of you who may be unfamiliar with Stonebridge, just a brief introduction. Stonebridge Capital Advisors is an SEC-registered investment advisor. We serve as a fiduciary for all of our clients, as well as any prospects that may be seeking advice from us. Fiduciary is a very important role that we believe we need to fulfill. Stonebridge has been fortunate to provide our services since 1997. We are an investment and wealth manager working with our clients to help them achieve their life goals. Normally, this time of the year, we would be having our estate planning, asset protection, and tax planning seminar that we've held at the J.J. Hill Library in St. Paul for the last few years. It's always been a wonderful and fun event. Unfortunately, COVID-19 has prevented us from being able to do that this year. And so consequently, what we've decided to do is a series of videos similar to this one that will focus on those concepts that we normally would do at our event. And so today is the first of several video series that we'll be providing to you, and hopefully you can join us at most or all of those. You should know that you can participate in the chat part of the video. We'll see your questions or your comments. We will certainly comment or return your questions after the video if we're not able to do it during the video. You can send us your comments or questions on the chat portion of the video, or if you email them to us, we will make sure that we get back to you directly and can do so either by email or by phone to have conversations with you. But today is the first of our events. We want to make sure that we're focused on your timelines. So we're going to try and keep our conversation to roughly 20 minutes or 30 minutes at the longest. And I'm going to let my partner, Ron Hume, start our conversation that's going to focus today on estate planning, asset protection, and planning in an election year.
Bob, thank you. Pleasure to be here, and thank all of you for joining us. The fact of the matter is that none of us want to think about our own or our loved one's death, but it is incredibly important as we go forward here in our current pandemic, and that we take some time as we all work together to overcome this, to look at some of the simple estate planning ideas and concepts that all of you should be aware of, and many of you are aware of. So the way we want to do this today is maybe to, rather than just rattle off some of those simple estate planning ideas, instead we'll talk about some of the things that Bob and I have seen over the years in working with many clients that are mistakes that are made to make sure that you are aware and at least think about these things. The first that I have seen over many years, and I think all of you will relate to it, and that is simply procrastination. I'll put it off until a later date. That is the number one that we see when we talk to clients. Do you have a will, etc.? And the idea is, well, not yet, but we'll get around to it. So let's do whatever you need to do to make sure that you move forward with some of these concepts. The second, and probably one of the more important aspects of estate planning, is to make sure that the beneficiaries on your accounts are the way that you want to have them. We have seen over the years unintended consequences of not updating beneficiaries to who you want the assets to go to. So as a matter of course today, maybe make sure you look at the accounts, whether it be bank accounts, brokerage accounts, insurance policies, etc. More importantly, 401k plans, as people have changed employers and left residual 401k plans at previous employers. Make sure to look at the beneficiaries. The next is, over the years, we've seen a number of people, again, unintended, but not have a will. And a will is extremely important, for it allows you to decide who is going to receive your assets and how you are going to provide for those that you want to have in your will. Importantly, for those of you that have underage children, a will provides for the guardianship of those children, and that's obviously extremely important. You want to be able in your will to name someone as the executor of the will. You want to name, as I just spoke about, a guardian for the will. You want to describe how you'd like to have your assets divided, including any charitable gifts. And you want to make sure that you sign and date your will. It's okay also to have someone witness that. Make sure that you know that your family knows where they can find the will. In today's digital arena, if you scan it and put it in your computer, make sure somebody knows how to access it. The next area that we see issues on is from the standpoint of not having a healthcare directive. And as we all get older, it's important for us to have a healthcare directive, to appoint someone to act on our behalf if we are incapacitated to make those decisions. So both husband and wife should have one, perhaps appointing each other, all in addition adding perhaps children. Also, as it relates to healthcare directives, and this is extremely important for those of you that have college-age children that are off to school. 18 years old is considered the age of majority. If our sons or daughters are off to school and something happens, the HIPAA requirements don't necessarily give you the access to information on your child, even though you are paying for their insurance and they're on your house. So it's important that when kids go off to school, have them sign a healthcare directive. Another area that is extremely important is that of a financial power of attorney. There are different names for it, durable power of attorney. But a financial power of attorney basically allows for someone that you trust to handle your financial obligations if you are unable to do so. So many times we see clients that all of us, nobody wants to get sick, nobody wants to be in an accident, but something happens and we're incapacitated and we can't pay the rent, we can't pay the bills, we are unable to carry on the simple functions that we need and typically do every day. So it's important to have a financial power of attorney to appoint somebody to do those things for us if we are unable to do so. Also important to know, and we run into this many times, is that a financial power of attorney ceases to exist upon your death. So just because you have a financial power of attorney, when we die, it is no longer valid. That's when it moves into the will and your beneficiaries, transfer on death designations, etc. Another area that we have seen over the years is treating children unequally when we split up the estate. Most people always think, just like we always do when we're giving gifts to our children at Christmas time, we think, oh, we got to all be equal. And many people do that upon their death. In their will, they make equal distributions to everyone. there are times when they're unequal due to whatever situations within the particular family. Our advice there is to make sure that if it is unequal, that is disclosed before we expire. Extremely important, because what's happening there is it's setting up the rest of the family to have issues with your desires. So that's an important thing, if not discussed with your family. Another issue is upon death, family members not being able to find the appropriate documents, or there's missing documents, or there are other issues that come about where documents say different things. So it is important to know where your documents are, have your family know where they are, where they can be accessed. As we talk about documents in today's world, Bob, you've dealt with this many times also, the digital age, making sure that your family knows what access there is to your computer, your passwords, what websites you deal with, if there's personal information that's filed, how to access it. Extremely important things we don't think about, but we need to do. Another area is charities. We're all very much charitably inclined. It's important to give. We see, however, from time to time, the gifting strategies are misused and misaligned. So we'll see when someone dies, the IRA is assigned to a charity. And the taxable portion of someone's estate is given to the heir. And what ends up happening with an IRA is, to a charity, an IRA is non-taxable anyway. So you might as well give the IRA to the charity versus giving the IRA to your heirs. Your heirs are going to inherit an IRA, they're going to take taxable distributions out of it, and they're going to pay taxes. So make sure that if you're going to gift from the IRA and not from your non-taxable or non-qualified accounts, because the children, the heirs, usually, at least at this point in time, are going to get a stepped-up basis on those assets. The last thing I want to talk about is missed opportunities with estate tax planning and saving as it relates to being able to gift while you are still alive. So as you all know, present law allows us to give $15,000 to any number of people that we choose. So it can be your daughter and your son-in-law, et cetera, et cetera. And you and your wife or spouse can combine to give $30,000. And you can do that to as many people as you want. You do not have to file a gift tax return. It is simply within the law to be able to do that. And simply what it does, it's doing two things. Number one, it's reducing the amount of your gifts from your total overall estate. And the second, and probably even more important item, is that it allows you to see the recipient enjoy and use the gift that you're giving. To the extent that you're going to give gifts that are more than that, then gift tax returns are going to be required, but you can do that. And then in addition to that, make sure that you understand that you can pay grandson, granddaughter's tuition directly paid to the institution. You can also pay medical expenses with gifts directly to the medical institution and not have to file any kind of gift tax return. So Bob, those are some of the things that I wanted to talk about today. We talk a lot about, and we have some forms that we can provide you if you would like. we talk a lot about making sure that you record where all of your documents are. Probably the most important thing. We get clients that come in and the husband or the wife doesn't know where anything is, and it just creates a lot of turmoil and a lot of extra expense. So in the days of COVID, as we are all sitting at home, we have some homework. We can do those things that looking at the beneficiaries for our documents, we can make sure we know where our documents are. We can take that time, which none of us want to do, record our passwords and figure out where all that stuff is. So, Bob, I'll hand it back to you to talk about some other strategies.
Well, and also as you go to review your documents, particularly review them relative to any significant changes that have occurred in your life. It may be the sale of a business. It may be the marriage of one of your children. It may be the divorce of one of your children. Things that have an impact on your life need to be taken into consideration in your estate planning documents and your beneficiary designations. So when you review them and you put your file together and where people can find it, make sure it's updated for those major changes in your life so that you're protecting the assets the way you want them to. Now, I'm going to take this a step further. I don't think it's any surprise that 2020 is an election year as well as a COVID year. And there are some unique planning circumstances that may require some of us to take action with their estate plan as soon as possible. Many of you are familiar with the federal estate tax deduction that is available to us. And that particular estate tax exemption, I should say, excuse me, is $11,500,000 plus. That's a big number. For any one individual, you have an estate tax exemption of $11,500,000.
$23 million per couple.
$23 million for a married couple. So it's a big estate tax exemption. We are hearing that Mr. Biden is considering making a change to that estate tax exemption if elected and has the Congress in his favor to reduce that back either to the 2016 estate tax exemption levels, which are approximately $5 million per person or $10 million per couple. That's a big reduction in the estate tax exemption. Now, there are also potentials that Mr. Biden has introduced that would essentially tax estates without any estate tax exemption, simply tax them as ordinary income, which would be a significant tax for your heirs to pay should you pass away on your estate. Now, there are lots of ways to protect against that happening in 2020. There are a number of strategies that could work, but those strategies are essentially around drafting documents to allow for you to make gifts either to your spouses or to your children through irrevocable trusts to assure that you have established your estate tax exemption at the 2020 levels. You filed a gift tax return to demonstrate that you have funded them properly, so that you've locked in that $11,500,000 gift tax for an individual, $23 million for a married couple. Now, those strategies are technical in nature, and so what we're advising our clients to do is, if you want to protect that $11.5 million gift tax exemption, or even are concerned about protecting the $5 million that you have going back to the 2016 laws, that you contact your estate planning legal counsel or your estate planning tax preparer to talk about what strategies might make the most sense for you in terms of gifting your assets to strategies that will allow you to claim that exemption in the year that it's available and complete a gift tax return so that you've demonstrated it's been fulfilled. It should be done in 2020. If the law changes in 2021, It may retro back to January 1st. We don't know that for sure. There have been changes in the state tax laws over the years. But as a precautionary measure, we advise that you get your documents together before year end and then assess by year end what gifting strategies you want to employ. We're happy to help you with that process. If for some reason you don't have an estate tax counsel that you're working with, we know of many very, very capable estate planning counsels around the country who can help you in the state of domicile that you live in. So if you're in Minnesota, you're in North Dakota, you're in Texas, we have contacts with people that can assist you in drafting those documents and preparing for your gift tax deductible exemption. So we want you to be aware of this. There is plenty of news and information out about this. If you'd like to have some of that information to understand what's being proposed and what might happen, we're more than happy to get that into your hands. So, Ron, I don't know if there's anything you want to add to that.
I just want to close, Bob, if you will, with a point that you made on how important it is when we talk about recording all of the documents and having someone else know where everything is. It's also important to know for your family members who your attorneys, who your CPAs, who your insurance person might be, and as well as investment advisors and bankers. They are your financial team. They know you the best. You assembled them because you trust them, and you want your family to know who they are so they can go to them so they don't have to be jumping all around and spending a lot of money trying to figure out what's going on. Another point that we often run into is appointing family members that do not necessarily have financial acuity or the wherewithal to do all the things that is required of someone who is the executor of the estate. And so, keep that in mind because there are a lot of moving parts. It's a lot of detailed work, and it creates problems for those who don't know how to do any of that. So, Bob, those are my parting comments. You want to close it up?
Sure. We talked a little bit about COVID-19, and I think in fairness to all of you, you're probably wondering, why aren't those guys wearing masks? I'll try to cover that for you. Number one, we're reasonably distanced. Number two, we wanted to make sure you could hear us in this conversation. But most importantly, so you all know, Ron and I have been quarantined here for quite some time, for the right reasons, by the way. Ron has a new grandchild that he's enjoying spending time with, and I'm about 2 weeks away from being a first-time grandfather. So we're trying to be as safe as we can, and also want you to know that it's important to be safe in this environment. So that's what we're doing. I would like to say thank you, though, for spending time with us, and I encourage you either through the chat section of this video, or if you'd like to send us an email with any questions, or if you'd like further information, we'd be happy to respond either by phone, if you'd like to set up a separate meeting, or if you'd just like something mailed to you, we're more than glad to do so. So with that, I want to say thank you again. Be safe, and we enjoy spending this time with you. Take care.
Good afternoon, everybody.